any specific categories of employees benefiting from certain protection in case of dismissals?
Yes. In Italy, there are some categories that are protected in the sense that unless you dismiss them for a just cause, a redundancy will be considered null and void. And in particular, pregnant women, parents of children up to 1 year old,
1 year,
women who have been married in the past year. So, yes, that's the reaction. So for these categories, the dismissal will be null and void. And then, of course, we have disabled people that may be dismissed at certain conditions, and of course, every dismissal that turns being, how can I say, discriminatory.
Okay.
Yes.
And for example, do you have, like we have in France, and Caroline will elaborate on that, protection for employees' representatives? Or?
Yes, but not in the case of the dismissal.
Okay.
But other protections, like if you want to move or transfer a union representative or an employee representative, you have to ask first the union representative office to do so.
Yes, indeed. You say, Antoine, in France we have protected employees. For instance, there are elected members of the so-called Social and Economic Committee or trade union representatives, pregnant women. And in that case, if you want to dismiss such people, the employer is obliged to ask an authorization from the labor inspector. And the labor inspector will check the situation and allow or not the dismissal.
What about Belgium, Pierre? Any specific protection?
Very strong protection for people's representative. For example, you want to terminate an employee who is at the work council for gross misconduct, you have to ask the court first. And actually it's a free world, because even if the court says no, you can say yes and I terminate the person, but in that case be aware that you may have to pay, depending on several criteria, up to 8 years of salary. So you can do whatever you want, but it has a price. Sometimes it's lower, it will depend on criteria like seniority or whether or not you're close or far from the next election of the body. Other protection are lower but still effective for women, pregnant women, for maternity leave, any type of protected leave. Then you can terminate someone. You cannot just terminate the person because of the reason, and then you have to prove that it's not linked to that and the burden of proof is on you. Otherwise, it's 6 months indemnity on top of the indemnity in your notice.
Interesting. In Austria, the specially protected groups would be pregnant women, parents on parental leave or parental part-time up until the 4th birthday of the child plus a cooling off period, disabled people if they have a special status of disability, works council members and apprentices. So these are the groups that enjoy special protection, and this means that you have to get a court's or special body's approval before you can terminate or dismiss them. Disabled people you may dismiss even without the court's approval, but for all the other groups you first have to ask the court or a respective official body for their approval, which can take quite a long time. And in Germany?
Thank you, Anna. Well, also this shows that there are many similarities between German and Austrian employment law. The situation is nearly the same in Germany. So with respect to parents on parental leave, pregnant women, disabled persons, it's basically possible to issue terminations by notice, but you need the prior approval by the authority. So without that approval, the termination would be considered null and void.
So thank you everyone for answering our questions. So you know what to do. Don't ask ChatGPT, ask your law firm an answer to your questions.